The importance of legal citations from the Boston College Law Library. How do you know what you know? How do you know what is true and not merely what you wish were true? What separates opinion from fact? And how do you convince someone else that you are correctly stating the law and not just your assumption or what you want the law to be? Legal arguments require statements of law to be supported by authority, which is indicated by legal citations. Citations are references to legal authority which may serve as precedent, such as a statute, a case, a regulation, or even a law review article. The statutes and cases that you cite are the bricks you use to build your legal argument. Citations are used to establish or support the proposition argued. Don't leave holes in your foundation. When in doubt, cite. Some types of legal writing, like law review articles, put citation sentences in footnotes so as not to break up the author's flow. But most documents you will produce in the practice of law, memos, briefs, even email replies to email questions, follow the formatting of most cases and use inline citations. This is because the citation is not an interruption to the flow of the author's voice, it is the basis of the author's support of the previous statement as law. The author uses the citation sentence to convince the reader that this is fact and not opinion. The citation includes indications of what type of law this is, how authoritative it is, and where the reader should be able to find it. It would be a distraction to have to look down at a footnote, or even worse, an endnote, to find out the decision in Goldstein v. California cited here is from the U.S. Supreme Court from 1973, or that Miller v. Universal City Studios is a 1981 case from the U.S. Court of Appeals for the Fifth Circuit. Legal citations serve three very important functions. They prove the argument is supported, they provide information on the weight of authority, and they tell the reader where to find the cited source. First, citations let the reader know this isn't just something you made up. There is support for this proposition. This is key to getting a decision maker to accept your arguments. I've heard stories of judges saying to attorneys, I want to find for your client, but you need to provide me with some authority I can cite to, or I will have to rule for the other side. Give the decision maker what they need to rule in your favor. Make their job easier. Citation is a way to advocate. The second thing citations do is communicate the type of source being cited, and therefore some indication of the weight of the authority. A statutory citation lets the reader know this is law that must be followed if it applies. Not all court decisions are created equal. Although a decision from a lower court or outside the jurisdiction may have very persuasive reasoning that a court may accept or reject, a court is required to follow the holdings of a court its decisions can be appealed to. Case citations let the reader know the court issuing the decision and also the date of the decision, two important factors in determining the weight of the authority. The third piece of information in a citation is a unique address the reader can use to find the authority cited. A conscientious judge or lawyer does not rely on someone else's interpretation of the law, but verifies that the cited item does in fact support the proposition the author asserts. The cited authority may also lead the reader to additional useful information. Chronological legal publications, like cases and law review articles, provide the address part of a citation in terms of volume number, name of book or journal that contains it, and page numbers, including both the first page of the case or article and also the exact page or pages being referred to. There could be many cases with the same name, but the Goldstein v. California being referred to here is in volume 412 of the United States Reports, beginning on page 546. The specific pages that support the preceding sentence are 651 to 652. The Patterson and Joyce article can be found in the UCLA Law Review, volume 36. The article begins on page 719 and the quote appears on page 763 in footnote 155. Topical publications, like statutory and regulatory codes, and many multi-volume treatises, provide citations by section number rather than page number. This allows for better translation from one version or edition to the next. For additional information on deciphering legal citations, check out our research guide, Reading Legal Citations, at lawguides.bc.edu/citations.